The Supreme Court has recklessly struck down state law that limits those who can carry concealed weapons.
That an American citizen a threat to themselves or others.
Over and over and over again. It begs the damn question, what the hell's going on in the United States of America?
Anytime there's a shooting, we play this ridiculous theater.
A piece of legislation changed their ability to hold a concealed firearm permit.
The Supreme Court overturned a federal ban.
The highest court in the land is preparing to deliver one of the most pivotal Second Amendment rulings since Bruen, yet nearly everyone beyond the legal sphere is ignoring it. The matter is Wolford versus Lopez, case number 24-1046. Appellate arguments were heard on January 20 to 26, with a verdict anticipated imminently, probably by late June or the start of July. Fundamentally, the justices must determine whether Hawaii may criminalize it, classify it as a misdemeanor when a licensed concealed carry permit holder enters a supermarket, a diner, a fuel station, or any privately owned venue accessible to the public, while armed with a pistol unless the proprietor has granted explicit consent. Let me put this clearly. Hawaii is informing individuals who cleared every hurdle, cleared every vetting process, obtained their license, that they are presumptively forbidden from bearing arms practically anywhere folks routinely visit in their everyday existence. And the bench seemed favorably inclined toward the firearm owners contesting that statute. I am going to explain precisely what this signifies for you, where this litigation sits procedurally here, and why the result could transform concealed carry statutes throughout the entire nation. Limitations on concealed carry being invalidated by the Supreme Court defend the Constitution. This panel convenes and recommends numerous statutes that would accomplish nothing to prevent. Here is why this is relevant to you individually, even if Hawaii has never been your destination. If the Supreme Court endorses this type of default prohibition, every state across the Federation receives a template. Consider that reality. You possess a concealed carry license in Texas, in Florida, in Ohio. It becomes irrelevant if the court declares a state may reverse the default so that privately owned venues open to the public are presumptively forbidden, unless the proprietor displays a placard or orally grants approval. Then firearm-opposing lawmakers in New York, California, New Jersey, Illinois, and Maryland will possess that instrument in their arsenal by the following legislative term. Your license would effectively become worthless in reality, because the locations you genuinely require protection, the parking area after dark, the retail complex, the eatery would all transform into legal snares. You would be perpetrating a misdemeanor merely by stepping across the threshold of a cafe, unless the proprietor had displayed a notice declaring firearms are permitted. How many proprietors do you believe will take the initiative to do so? This is not theoretical. This represents the concrete legal structure Hawaii constructed, and multiple other jurisdictions are monitoring this litigation to determine whether they may replicate it. Are sacrificing children because of firearms and the bloodshed from the lawlessness unleashed by those jurisdictions. The effect of these statutes enables us to conduct an educated, informed dialogue as a society regarding what genuinely functions. Would you visit your neighbor's residence and seize his lawfully possessed arms? A gentleman who was neither subject to criminal inquiry nor detained? Would you undertake such an action? Very well. So permit me to guide you through the legal framework here. On June 2nd, 2023, Hawaii passed Act 52 that constituted their immediate reaction to the Supreme Court's historic 2022 ruling in New York State Rifle and Pistol Association versus Bruen. The litigation where the court ruled in a 6-3 opinion penned by Justice Thomas that the Second Amendment safeguards an individual's entitlement to transport a pistol beyond the residence for personal protection. Bruen invalidated New York's proper cause prerequisite for concealed carry licenses and formulated a novel standard. Any contemporary firearm statute must align with the country's historical pattern of firearm governance. Hawaii examined that verdict and basically responded, "Very well, we shall grant licenses, yet we shall render it unlawful to bear arms nearly everywhere of significance." Act 52 established what is termed a private property default regulation. Under this regulation, transporting a firearm onto any privately owned premises accessible to the public constitutes a misdemeanor unless the proprietor or manager grants explicit consent orally, in documented form or via prominent and visible signage. Observe what they accomplished there. They inverted the default across most of the United States. The presumption is that you may bear arms on privately owned premises accessible to the public, unless the proprietor displays a notice forbidding it. Hawaii completely reversed that. You are prohibited unless you secure affirmative consent. On June 23, 2023, merely 3 weeks following Act 52's enactment, concealed carry license holders Jason Wolford, Allison Wolford, and Adam Kasperzicki, together with the Hawaii Firearms Coalition, initiated initiated litigation against Hawaii Attorney General Ann E. Lopez, acting in her official role. They contended that Act 52's default regulation essentially eviscerates the public carry entitlement that Bruen acknowledged. The litigation advanced through the United States District Court for the District of Hawaii and upward to the United States Court of Appeals for the Ninth Circuit, which ruled in favor of the state. The Ninth Circuit determined that Hawaii could presumptively forbid carry on privately owned premises accessible to the public. They reasoned that proprietors possess a customary entitlement to prohibit firearms from their establishments and that the state was merely codifying that power as a default. The petitioners subsequently sought certiorari, signifying they petitioned the Supreme Court to accept the matter, and the court approved it in October 2025. Oral arguments transpired on January 20th, 2026, and accounts from that session indicate the justices seemed favorably disposed toward the challengers. That carries weight. The inquiries from the bench implied doubt regarding Hawaii's stance that a sweeping default prohibition aligns with the historical tradition the Bruen standard demands. Now, allow me to provide the background that the majority of reporting on this litigation entirely overlooks. This is not occurring in isolation. An active circuit division is materializing on this precise matter. While the Ninth Circuit affirmed Hawaii's opt-in prerequisite, the United States Court of Appeals for the Fourth Circuit reached the opposite conclusion. They invalidated a comparable Maryland provision of private property default regulation that similarly demanded affirmative consent before a licensed carrier could enter private premises with a firearm. Fresh cert petitions have already been submitted requesting the court to examine that Fourth Circuit ruling as a companion matter. The reality that federal appellate tribunals are arriving at contradictory conclusions on functionally indistinguishable statutes is precisely the type of conflict the Supreme Court was created to settle. That renders Wolford versus Lopez even more significant. The court is not merely adjudicating one jurisdiction's statute, it is establishing the regulation for the entire nation. And observe what else is transpiring on the Second Amendment calendar presently. The court has numerous substantial firearms litigations, either pending or in the queue. Challenges to semi-automatic arms prohibitions, Hiramontes and National Association for Gun Rights, and large capacity magazine restrictions such as Duncan and Gator's custom firearms were deliberated at conference as recently as April 17, 2026. They still lack any public signal of their trajectory. Meanwhile, in the subordinate tribunals, fresh litigations are being submitted continuously. Lopez versus City of Los Angeles, case number 226 CV0603, was submitted on June 3, 2026. Contests Los Angeles and Inglewood's prohibitions on acquiring more than one pistol within a 30-day time frame. Elite Precision Customs versus ATF is progressing through the United States Court of Appeals for the Fifth Circuit, contesting the federal prohibition on interstate pistol transfers from licensed vendors. Heater versus James is contesting New York's body armor limitations in the United States Court of Appeals for the Second Circuit, and the Fifth Circuit just witnessed its ruling in United States versus Cockerham, number 246401, stand after the Supreme Court denied certiorari on June 4, 2026. That represents the litigation where a three-judge panel determined that Section 922G1, the federal felon in possession statute, cannot enforce a perpetual firearms prohibition based exclusively on a nonviolent debt-related offense once the underlying obligation has been fulfilled. The panel characterized Section 922G1 as wildly over-inclusive. The implication is, this Bruen opened the floodgates, and presently subordinate tribunals and state assemblies are locked in an enormous struggle over what it genuinely signifies in application. Wolford sits at the heart of that conflict because it resolves a question Bruen left unresolved. Does your entitlement to carry extend to the locations where you genuinely conduct your daily existence? Or may a jurisdictions effectively exclude you from exercising it? So allow me to offer you the candid evaluation. Is this an assured victory for firearm owners? Negative. The court could rule restrictively. They could declare Hawaii's particular execution unconstitutional, without confronting the wider question of whether any default regulation is allowable. They could alternatively affirm the statute, though the tenor of oral argument renders that less probable. The most robust indication we possess is that the justices seem doubtful of Hawaii's argument that the state is merely codifying proprietors' existing entitlements. The challenger's stance, articulated by counsel Pete Patterson, Bruen requires a historical parallel for any limitation on the entitlement to bear arms. Hawaii, has failed to present an authentic historical tradition of jurisdictions enforcing sweeping default prohibitions on carry throughout all privately owned premises accessible to the public. Legal academics such as Akhil Amar and Vikram Amar have contributed their perspectives. Constitutional law scholar Erwin Chemerinsky has publicly characterized the present condition of Second Amendment jurisprudence as, in his words, chaotic. He is not incorrect in that assessment. Yet the chaos exists specifically because subordinate tribunals have been attempting to circumvent Bruen rather than dutifully applying it. Here is the present situation. Wolford versus Lopez has been argued the justices are drafting their opinion. The verdict could arrive any Thursday or Monday between now and the conclusion of June or early July 2026. The tribunal's forthcoming opinion days encompass June 11th, and conference dates are scheduled for June 11th, 18th, and 25th. If you are a concealed carry license holder in Hawaii, you are presently subject to Act 52 limitations. Transporting onto privately owned premises accessible to the public without explicit authorization remains a misdemeanor until the court rules otherwise. If you reside in a Ninth Circuit jurisdiction that encompasses California, Oregon, Washington, Arizona, Nevada, Montana, Idaho, Alaska, and Hawaii, this ruling will directly govern your carry entitlements. If you are located anywhere else across America, remain vigilant because whatever framework the court constructs here will dictate every forthcoming challenge to comparable statutes. Your entitlements are on the calendar. The verdict is approaching. That concludes today's discussion, everyone. See you in the next video.